Welcome back, students. Today we will complete the topic of torts in cyberspace. And it's very important that all of you have a good grasp of the issue of how torts can occur in cyberspace, mainly because, number one, you have not actually done torts in your, law courses before. And number two, other than contracts in your field, you are also going to be involved in torts in the context of your personal life or in the context of your business, right? Because either intentionally or unintentionally you may have committed a civil wrong with individuals whom you have never met before, either knowingly or unknowingly. In the context of business, if that happens, you can definitely be liable, right? So even if you, do not, go into the depth of this area, but you have to know roughly what torts are. And then number two, how torts can occur in cyberspace, all right? Now, as you have seen before, torts can take place in three ways. And remember, when we're talking about torts, generally, we are talking about torts that take place both in our physical world and in cyberspace. Now, if you look at torts, from the lecture that we have done so far, we have seen that there are three categories. One is intentional torts, the second is negligence, and the third is strict liability torts. Now, we've already looked at all these three categories, but I want to quickly run through it. Intentional torts basically mean that the civil wrong committed was done with the intention of, causing distress on the plaintiff. All right. Now, in the context of negligence, in this case, what happens is the person, his actions are such which a reasonable person would not do because he did not actually, carry out his duty of care, and he had breached that duty of care, and as a result, he had caused harm on the other person. All right. Now, in the context of strict liability tort, the issue of intention is mute. Mute meaning is silent, meaning the law doesn't require you to prove intention. In the context of strict liability torts, normally these are areas in which there is high risk, and therefore the defendant is imposed by law to have higher duty of care, or what you say, strict liability is imposed on the defendant. Now, certain areas of this, including like manufacturers liability, employers liability, occupiers liability, all of these areas are considered to be strict liability torts. Okay. Now, if you look at damages, you can see in the area of torts, if the plaintiff is successful in proving their case, then the defendant has to pay damages to the plaintiff, and the damages can be compensatory damages in the form of money, monetary damages, or it could be in the form of punitive damages or nominal damages. All right. And at times, the court will issue an injunction if the plaintiff asks for it. Injunction is an order of the court to stop the defendant from continuing with the act that is causing losses to the plaintiff. And these type of injunctions are often seen in the case of intellectual property kind of cases. Okay, so you can see damages are ways in which the plaintiff tries to recoup his losses that was caused by the defendant. All right. So we have already looked at what is an intentional tort. Oftentimes, intentional tort which the defendant commits will cause injury or harm to the plaintiff. And some forms of intentional torts are such as physical trespass, assault, battery, false imprisonment, all right, as well as intentional torts that occur in business with the help of advances in technology. And these include, cyber stalking, invasion of privacy, misappropriation of information, defamation, etc. Right? So all of these things are issues that are currently ongoing in cyberspace, and with more and more businesses, opting to become e-businesses, you will find that these are things that they should have some level of awareness about. All right. Now, so it's very important that all of you, begin to have an idea about, torts in cyberspace, and of course, torts in, um, you know, um, okay, not only torts in cyberspace but also torts in our physical world, right? And one of the areas we looked at is in terms of privacy or privacy. And again, this particular type of issue is very important because your information in cyberspace is more easily accessible, right? So it's very important for you to understand the ways and means for you to actually protect your information. And you have got new laws such as Data Protection Act, which actually helps you to be aware on ways in which your information can be misappropriated by others, and how this can actually cause harm if it is if it is wrongly used or if it is misappropriated. We have also looked at another area, which is a defamation, and we've looked at two forms of defamation, which is actually, libel and slander. And in the context of what do you call it, cyberspace, these kind of, should I say, intentional tort will become much more, magnified, because the scope and reach of the internet is not just a particular location, but throughout the world, right? So again, when you look at libel and slander, when you talk about cyberspace, these issues become very problematic. But as you can see, the most important thing about defamation is that you have to prove that the plaintiff has to prove that the information that has been posted about him or her is not true. All right. So the intention there is that the person, has a posted information, either which he knew was untrue or he did not check to see whether the information was true or untrue. And then, definitely the resultant harm has caused to the plaintiff's reputation. All right. So these are things that, you have seen so far in the context of intentional torts. We then looked at fraudulent misrepresentation on internet transaction, such as ordinary sales transactions and financial investment transactions, where the elements of deceit and fraud, similar to what you all have studied in contract law, is present. All right. Now, so you can see how these occur in the internet, where, for example, the seller collects payments but does not deliver the goods, or there's a lot of fraudulent, misrepresentation going on in the context of investments, where people, try to deceive others to invest in companies that are not doing well or that are non-existent, right? So these are examples of fraud taking place in the context of cyberspace in relation to internet transactions. Okay, now so you can see another area is in the context of conversion, which is the equivalent of theft in criminal law. Conversion meaning basically you take and use someone else's property without permission or without justification. All right. Now, again, this can happen in cyberspace in the context of trademarks, or when you actually use somebody else's trademarks or trade names, and you try to use it to your advantage, or you link certain websites in your website without taking without getting the necessary permission, right? So there are different ways, you can, do this conversion, right? And so it's important for you to see how these kind of civil wrongs or intentional torts, can occur in cyberspace. Now, not only do you see this particular issue of conversion happening in cyberspace, but you have to see what are current issues related to conversion, for example. All right. So how do you know what is a current issue? So you will see how there are certain technologies that are making these things very easy to occur. All right. Now, one area of this is called identity theft. You have heard of identity theft, right? So somebody takes the identity of another person, and then that person is deprived of his own identity, and he's unable to actually function because of that. So there are different types of conversion that can occur in cyberspace. All right. Now, so you can see it's very important for us to figure out what a current issue is by exploring and by also looking for what's happening generally and seeing how that could actually relate it to your area of topic. So it's very important for us to do that, because otherwise, your group project may not be, you may not be able to actually, come up with a good output. All right. So you can see when you talk about wrongful takings and intermeddling, can occur in personal property, real property. It can also occur in cyberspace, and normally in cyberspace you talk about trespass. All right, trespass. All right. Now, trespass in cyberspace can occur, which we've already discussed. This is through aggregators, like auction websites that put together a couple of different auctioneers in one website, and then in without permission, and then they use certain softwares to do that, and then that could be considered as trespass. All right. Now, so there are very many ways in which this can actually take place. Another area is misappropriation, where you use somebody famous to sell your product or to get consumers to buy your product, giving them the wrong impression that they are actually, promoting, or they are actually, like allowing you to use their image or their name, right? Again, that could be related to misappropriation, right? So these are examples that we had already looked at. We've also looked at negligence, what is negligence, and the elements that the plaintiff has to prove, such as duty of care, breach of duty of care, and damage occurring. And you look at the issue of causation. Did the breach directly cause the damage to plaintiff? All right. And was the harm foreseeable? Could the defendant foresee that such a harm will occur? Right. And if he could foresee it, then he had the duty to actually make sure that he did not actually engage in that act. So you saw what is foreseeable harm. I showed you a couple of videos on that. and then you looked at proximity. All right, so all of these things were elements that we looked at, right? Chain of causation, we looked at the issue of proximity, all right, and so on, all right. Another area we looked at is, in terms of, the physical space. We talk about trespass, and we looked at the duty, whether, the owner of a property has got duty towards those who are trespassing in his land. And the answer was no, there was no duty of care towards those who are trespassing on his land without his permission. However, the owner of a property does have a duty towards licensees or business invitees, those who you invite into your property, right? So we saw that, and so that's basically in terms of trespass. But I wanted to actually added a couple of more slides for all of you to see, and these are examples of trespass in cyberspace. The first is a spam email. Now, if you look at spam email, many of us have obtained spam email, and but you don't realize it is actually an area of trespass in cyberspace. Now, why is it trespass? Because people are sending you, email without you actually giving them permission, right? So you can see a lot of these are key elements of property and permission, right? Is involved in the context of spam. Now when you look at spam, how does spam occur, or what is the process in which the spam arise into your your email account, right? Actually it goes through two levels of properties, because remember, for trespass it shows that you have to enter a property without permission, right? So if you look at spam, basically the spam does have these two key elements of property and permission. Number one, the spam will travel through multiple servers from the sender of the spam to the person who ultimately receives the spam. All right. So there are basically two levels of properties. One is in terms of the server, all right, which is it could be the recipient's mail server or some intermediate server, right? So they're the ones who are going to actually bring the message to your email account, right? So at one level, they are trespassing the, either the mail server or the intermediate server, all right? That's the first level. The second level of trespass occurs at the end user's hard drive space. That is, for example, if it is you, then it is going to be your hard drive space. They're taking up your hard drive space, the spam, all right? So, or it could take up the space of your email account. So either way, there's a trespass occurring, because your email account or your hard drive space on your computer is also, property, right? Your property, okay? So when it enters into that space without permission, there is trespass occurring. All right. So you can see how a spam email constitutes trespass. All right. And normally it occurs without permission, because a lot of these, they are using the, spam email for marketing purposes or for business purposes. And in that context, right, they send you unsolicited email, and this email passes through two levels of property, the server, as well as your email account or your hard drive without permission, right? So that's the first example of trespass in cyberspace. The second example is active email, all right? Now, what is that, all right? Like you will see that today there's a lot of what you call hypertext markup language extended email, right? So where the HTML becomes truly active component in the email through add-ons like Java and JavaScript. All right. So it's not like long ago, our email is not passive anymore. It has got these add-ons which actually has got active components. So when you actually download this email message from the server to your, hard drive space, all right, in your personal computer or your email account, there are some very unexpected consequences. All right. Now, what happens is the user is not aware that her spare CPU cycles are used for the Java applet's author's benefit. All right. So what happens is basically it's like there are bugs, in the mail client's implementation, and they use certain technologies like the ActiveX, or some other current technologies, which can actually read your local files, all right, and upload them back, all right, to the person who is trying to extract information from your uh, computer or email, all right. So these are bugs basically that could do that, right? I don't want you all to go into the depth of it, but just roughly understand that currently the email is not passive, it is active because there are certain components or add-ons attached to it that is able to actually come into your space, all right, whether it is your hard drive or your email, and then it can read certain information there and then take that information back to the person who had sent that, all right. So again, you can see how these active emails can actually cause trespass in some form or manner. All right. The third is hacking of a web page. All right. Now, if you're a business and you have a web page, all right, and sometimes, because of certain weaknesses in the way you have designed the web page, all right, a lot of, damage can be done to your business because these hackers are entering into your web page without authorization. So again, trespass here, right? And they're going to cause enormous damage to your information in your web page, or you understand, or it causes your web page to malfunction, and so on and so forth. So again, it causes a lot of damage, right? So these are things you can see that comes in the hacking of a web page will be trespass because it's done without your authorization, and then it causes harm to your property, right? And thereby, there is damages to your business, all right? So they had actually equated web page hacking to something that occurs in the physical space, like somebody going into your property and planting a tree in there, or spray painting somebody's shop storefront, right? So these are examples that they have equated web page hacking to, right? And normally what happens is the person who hacks your web page, they change the content of your web page by adding files to the web server, right? Now, by doing that, they are actually, committing trespass because they're doing it without permission, all right? So so even though it's because of a kind of a weakness in your web page, they are able to do that. But even though there's a weakness in your web page, they should not do that without your authorization. It's like you have a fence and there's a hole in your fence, and people are saying, well, there's a hole in the fence, so I came to your property. Okay, that's not a legitimate argument. So similarly, even if there is a weakness in your web page, it doesn't give the trespasser a right to enter into your web page and do things without your authorization, right? So this is the third example of trespass in cyberspace. And then finally, breaking into your personal computer, right? And this is by virtue of certain functions that advanced computer systems have these days. Due to advanced operating systems, right? You can actually access another computer remotely. Sometimes we allow certain people to access our computer remotely, right? That means they're not here, but they are in another location, but they can access what is in your computer. So if you look at your computer, there are settings that, where you can actually allow someone to access your computer remotely. Now, sometimes these kind of functions can allow unauthorized people to enter into your personal computer and even commit identity fraud or identity theft and so on. All right. So again, another way which trespass occurs by breaking into your personal computer. All right. So I just want you all to be aware of these kind of issues, because in the event you decide to actually have an e-business, these are things that you should be conscious about, and also perhaps make sure that you have this awareness so that you can protect your e-business. All right, now we come into another area which is called professional negligence. All right, normally this involves doctors, accountants, lawyers, all right, where because by virtue of the fact that they are a profession, there's a standard of care expected in terms of the delivery of their services to the customers, all right? So generally, if you look at any profession, they have a standard of care when they are delivering services. All right, so it's similar to negligence, except the standard for professional services is a notch higher. All right, and normally those who are in a profession, they actually are, when they say they're in a profession, normally there's going to be a body, a professional body that is going to be overseeing them. So that means they have to register, and then they have to actually have some form of liability insurance in order to protect their business, all right, or their profession, all right, like lawyers, doctors, accountants, and so on, right? So these are areas where because you hold yourself to be a specialist in a certain area, you have a higher standard of care, right? Now, so that is in terms of professional negligence. Now, there comes another, concept, which is called res ipsa loquitur. Okay, res ipsa loquitur. Now, as you all know, in all cases, there is a presumption of innocence until plaintiff can prove the elements of liability. In the case of civil cases, there is a presumption that defendant is innocent until the plaintiff proves that the defendant has done something that he or she is liable for, right? So it's the plaintiff who brings the case who has to prove the case in order to get damages against the defendant, right? So he has to prove the elements of liability. So in the case of negligence, for example, plaintiff has to prove defendant has a duty of care towards him. Number one, number two, defendant had breached that duty of care, and number three, as a direct result of that breach, there has been causation. That means the defendant's action had caused plaintiff direct, damages, right? And it was foreseeable that his action will cause the damage, but he did not take the reasonable steps necessary to avert the harm that happened to the plaintiff. All right. Now, but so usually it is the burden to prove the case is on the shoulder of the person who's bringing the case, that is the plaintiff. But in certain situations, the burden will shift to the defendant. And this is the case in strict liability cases as well. In strict liability cases, it is the defendant who has to prove that he did not cause that harm. All right. But anyways, generally, the plaintiff has to prove the case, prove the elements of liability, but in certain situations, it will shift to the defendant. All right. Now, and that is what you call res ipsa loquitur. It basically means the thing speaks for itself. Now, if this doctrine is raised by the plaintiff, then the burden of proof will shift to the defendant. Right? Now, I will play this video for you so that you have an idea what is res ipsa loquitur.
In this video, we will discuss res ipsa loquitur. Res ipsa loquitur is a principle that helps a plaintiff to prove negligence because the accident speaks for itself. That is, because of the accident, the jury can presume that the defendant must have been careless. In the United States, to win a negligence lawsuit, the plaintiff must prove that the defendant owed her a duty to be reasonably careful and that the defendant breached her duty of care. The defendant acted carelessly. Res ipsa loquitur is important because sometimes it is difficult for a plaintiff to prove that the defendant acted carelessly. For example, let's say Patty is walking down the street by Debbie's house. Suddenly, a refrigerator falls from Debbie's house, and Patty is hurt. So Patty sues Debbie for negligence. But it might be very difficult for Patty to prove exactly how Debbie was careless. After all, Patty didn't see Debbie do anything. Under these circumstances, Patty might be able to rely on res ipsa loquitur. To rely on res ipsa loquitur, a plaintiff usually has to prove two things. First, that the accident normally wouldn't have happened unless someone acted carelessly. Here, a refrigerator fell from a house. That's pretty unusual. It wouldn't have happened unless somebody acted carelessly. Next, the plaintiff should be able to prove that the defendant was in control of whatever caused the accident. Well, this was Debbie's house, Debbie's refrigerator. Who else but Debbie could have caused the accident? So, sure, Patty did not see Debbie do anything careless, but if the judge allows it, Patty will be able to rely on res ipsa loquitur. The accident speaks for itself. The jury will be allowed to assume that Debbie breached her duty of care, that Debbie was careless. If you'd like to discuss res ipsa loquitur.
So you could see basically from the video what is res ipsa loquitur. Basically, if in certain cases you can't really, prove, then you know that that action would not have happened if defendant was not, uh, you know, uh, negligent, and you can use this res ipsa loquitur defense. Now, another defense, defending liability. So that means the res ipsa loquitur is for the plaintiff to use. All right. Now, but the defendant can also use, certain arguments for defending themselves in a case, what you call as superseding or intervening cause. All right, that means that you remember we talked about the chain of causation, right? Remember that dominoes effect, right? Now, maybe something was in between there that had broken the chain of causation. Let's just say defendant did something and plaintiff had the harm, right? But something happened in between there that broke the chain of causation, meaning defendant's action was not directly causing the harm. Something else also had taken place, and therefore it had, broken the chain of causation. which means that the defendant may not be the only person that had caused that damage or injury to the plaintiff. All right, so that's one, the superseding or intervening cause, which has actually broken the chain of causation. All right, remember, I think one of the videos actually showed that it's in terms of the fire, right? The fire, there was a forest fire, and then somebody goes and pours kerosene on the house, but it is the forest fire that actually caused it, and not this, the kerosene that they poured on the house, or somebody broke the glass, and was that the main reason, which the what do you call it, the windows were broken, or was it something else, right? So these are called superseding or intervening causes that may actually break the chain of causation. So if defendant can prove that something else actually also happened, and it's not his action that had actually caused the harm to the plaintiff, then the defendant escapes liability. Now, the other is about volentia non fit injuria, right? Again, I think there was a video on that. Like, for example, if, say, for example, you are a boxer, right, and you go and you do boxing in the ring, and you sustain injuries, of course. But as a boxer, you know that when you enter into the ring, you are assuming certain risks in that particular activity. All right. So they use the word volentia non fit injuria, meaning you voluntarily, accept the, injuries that occur in that activity. All right. So that could be actually a defense. So if plaintiff brings an action against a defendant, defendant can say, look, you knew the risk for that activity. So actually you had already voluntarily assumed that risk. So I am not responsible for the harm that has occurred to you. All right. Another defense is what you call contributory negligence, right? That means that yes, the plaintiff had suffered harm, but the plaintiff's action had also caused the harm that had occurred to the plaintiff. So not only defendant's action, but plaintiff's action had also contributed to the harm that had occurred to the plaintiff. All right. So basically, the defendant, of course, have to prove that. But nevertheless, that is one of the defenses that a defendant can use in a action brought against him. Now, let me show this video on contributory negligence so that you can see what it means.
In this video, we will discuss the common law rule of contributory negligence. The contributory negligence rule is that plaintiffs who carelessly help cause their own injuries recover nothing in a negligence lawsuit. Let's say Perry is carelessly playing a video game as he crosses the street. Here comes David, who is going too fast on his skateboard while listening to music. And David slams into Perry. And we'll say Perry sues David for negligence and wants $100,000 in damages. The jury decides that David is 99% responsible for the accident. But Perry is 1% responsible too. The jury concludes that Perry was also careless. Playing a video game while crossing a street was contributory negligence. And our traditional contributory negligence rule is that Perry gets nothing. Most states in the US no longer apply traditional contributory negligence rules. If you'd like to discuss contributory negligence,
Okay, the next concept we're going to look at is on volentia non fit injuria, All right, and I will play the video for you on this.
Valenti non fit in iuria is a common law doctrine which states that if someone willingly places themselves in a position where harm might result, knowing that some degree of harm might result, they are not able to bring a claim against the other party in tort or delict. Valenti only applies to the risk which a reasonable person would consider them as having assumed by their actions. Thus a boxer consents to being hit, and to the injuries that might be expected from being hit, but does not consent to his opponent striking him with an iron bar, or punching him outside the usual terms of boxing. Valenti is also known as a voluntary assumption of risk. Valenti is sometimes described as the plaintiff consenting to run a risk. In this context, valenti can be distinguished from legal consent in that the latter can prevent some torts arising in the first place. For example, consent to a medical procedure prevents the procedure from being a trespass to the person, or consenting to a person visiting your land prevents them from being a trespasser. English law. In English tort law, valenti is a full defense, that is, it fully exonerates the defendant who succeeds in proving it. The defense has two main elements: the claimant was fully aware of all the risks involved, including both the nature and the extent of the risk, and the claimant expressly or implicitly consented to waive all claims for damages. Knowledge of the risk is not sufficient, science non est volens. Consent must be free and voluntary, that is not brought about by duress. If the relationship between the claimant and defendant is such that there is doubt as to whether the consent was truly voluntary, such as the relationship between workers and employers, the courts are unlikely to find valenti. It is not easy for a defendant to show both elements, and therefore comparative negligence usually constitutes a better defense in many cases. Note, however, that comparative negligence is a partial defense, that is, it usually leads to a reduction of payable damages rather than a full exclusion of liability. Also, the person consenting to an act may not always be negligent. A bungee jumper may take the greatest possible care not to be injured, and if he is, the defense available to the organizer of the event will be valenti, not comparative negligence. Consent to medical treatment or consent to risky sports on the part of the claimant excludes liability in tort where that consent is informed consent. United States, the similar principle in U.S. law is known as assumption of risk.
Okay, so you can see basically what this whole concept of volente is. Basically, the plaintiff assumes the risk, and therefore the defendant will use it in the defense to say that whatever harm that had occurred to the plaintiff is because he assumed the risk in that activity. So he knew that he would potentially will suffer injury. All right, so example is like the boxer in the ring, or if you're going for surgery in the hospital and the surgeon cuts you open, you cannot then sue the surgeon to say, well, the surgeon has caused injury on you, because you knew the procedure will involve the doctor cutting you open. All right, again, this is an example of that. All right, so these are examples of defenses that one can use when the plaintiff sues you, to say that the plaintiff basically knows that 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 the activity has certain risks, and he knew that it had risk, and he had knowingly engaged in that activity, and therefore the harm had resulted. All right, a bungee diving, for example, right? So these are examples where you can use the defense of volenti non fit injuria. Okay. And next is a strict liability, right? Another category of torts for which the liability for injury is imposed for reasons other than fault. So even though the person did not cause it, but because there is a higher standard of care imposed for certain high risk activities, right? then this particular area of tort will apply. Now, for example, if you look at some of these factories, they actually uh, either store hazardous waste, or they actually, like for example, they will dump hazardous waste into the river, right? Sometimes done by the employees. But then the law will impose strict liability by suing the organization or the company that was responsible, and they will impose strict liability because the storing of hazardous waste has caused an explosion, and therefore there'll be strict liability. Or by dumping hazardous materials into the river, polluting the river, right, and causing harm to the people in a particular location. Again, that would be strict liability, right? So these are examples of strict liability under tort. All right. Another area is product liability. You buy a product, has certain, defect, and the consumer using it has suffered harm. Right. Now, again, right, you will see in this context a lot of cars recently. Yeah. You had seen that either the car had certain defects that may have caused the car to explode, or if the car had certain features which actually cause harm on the user, right? This will come under the strict liability. All right. So of course, in the context of business owners, they have to be aware if they're going to use certain products, they have to be careful. Or if they're manufacturer of certain products, they have to be careful that if the products cause certain harm, then they will be liable under strict liability, right? Of course, we already looked at spam just now, right? And spam, we looked at the features of spam, all right, and trespass. Okay. Now, okay, now if you look at this case, Hotmail Corporation versus Vance Money Pie, the court found a likelihood that defendant committed trespass, all right, by sending spam emails containing false return addresses bearing Hotmail's account return addresses to thousands of subscribers using plaintiff's email on the World Wide Web. All right. So these are examples, right, of trespass, of cases which actually, was taken to court, right, where a spam was, actually considered to be trespass, and, damages were given. All right. Now, so messages advertised to get rich quick schemes, pornography, and other advertisements, right? All of these things, can actually, come into your email, right? And can be considered to be spam, all right, and trespass, right? And the victim can actually sue and obtain damages for the purpose, right? And finally, we come to the topic of vicarious liability. What is vicarious liability? Normally, a defendant is liable for his actions that directly cause harm to the plaintiff. So basically, plaintiff will sue defendant because defendant's action had caused harm directly to him. All right. But in certain circumstances, even though you did not cause the harm, somebody else caused the harm, but you can become vicariously liable. So even though it was not your actions that caused harm to plaintiff, but somebody else's actions that caused harm to plaintiff, but you can become vicariously liable. So this is usually in the situation of employers and employees, right? So when employees do certain things in their course of work, and it had caused harm to third parties, then third parties who will be the plaintiff can bring an action against the employer and sue for damages. All right. So even though the employer was not directly responsible, but through the act of the employee, the employer becomes vicariously liable. All right. But if it is somebody who is an independent contractor, right, who is actually, working for, you, right? Then if his employee causes harm, then you will not be directly liable, but the contractor will be liable. All right. So this is an example of negligence. But here, even though you did not cause the harm, somebody else causes the harm, but you will become vicariously or indirectly liable, right? So that's an example of vicarious liability. So, for example, if say, for example, somebody who is doing renovation in your house, right? And while they were doing, carrying the bricks or operating the crane, they caused harm to the neighbor, right? Now the issue is always whether that person who is working for you is working for you, or is it working for a contractor that you have hired. So if that person is the employee of the contractor and not your employee, then you will not be vicariously liable, but the independent contractor will be liable for the harm that has happened to your neighbor. So that's the example of vicarious liability. All right. Let's see if I can play this video for you on vicarious liability.
Vicarious liability. Vicarious liability is imposed when another person is held responsible for the tort of another person. Hence, this is a type of secondary liability which is strict. 3 conditions have to be established. 1. There has to be a tort, otherwise there would be no claim. 2. There has to be something like an employment or agency relationship. 3. The act or omission has to have been committed in the course of employment. To establish the second condition, it is important to apply various tests in order to show that there is an employment relationship. The control test, the integration or organization test, and the economic or multiple reality test. The economic or multiple reality test is the most popular test. To establish the third condition, i.e., that the act was committed in the course of employment, it has to be shown that the employer directly or indirectly authorized the act, or this was incidental to what the employee had to do, or that the employer had authorized that the employee performs the unauthorized act. It is broadly construed what is not in the course of employment. There exist special categories, for example, where an employer has given an express prohibition, or an employee has deviated from an authorized route, or has committed a criminal act and has breached a statutory duty. And generally, employers are not liable in these instances. However, the courts have taken a flexible approach. Also note the following in respect of lending employees. When one employer lends an employee to another, the general rule is that the first employer is liable, but vicarious liability may also be imposed on both employers. Moreover, not only an employer, but also a principal can be held vicariously liable for the tort which has been committed by an agent, so long as this falls within the authorization or employment. Whilst independent contractors are responsible for their own acts, the courts have also permitted various exceptions. In the Supreme Court case, Catholic Child Welfare Society and Oars versus various claimants, 2012, It was explained in paragraph 34 that the policy objective underlying vicarious liability is to ensure, insofar as it is fair, just, and reasonable, that liability for tortious wrong is borne by a defendant with the means to compensate the victim. In this case, it was also explained at paragraph 35 that there exist various policy justifications. Fundamentally, that the employer is more likely to have the means to compensate the victim, but also that the tort will have been committed as a result of activity being taken by the employee on behalf of the employer. The employee's activity is likely to be part of the business activity of the employer. The employer, by employing the employee to carry on the activity, will have created the risk of the tort committed by the employee. The employee will, to a greater or lesser degree, have been under the control of the employer.
Okay, so you can see that basically why vicarious liability has been imposed. Basically, it's a policy issue. Secondly, a lot of the activities, for example, that an employee undertakes in the course of employment is because he was asked to do that by the employer. And if it causes harm to third parties, then the employer is in a better position to pay damages to the victim or to the plaintiff as opposed to the employee. Okay, number one. Number two, you look in the context of businesses, you've got principal and agent is carrying out the duties on behalf of the principal. Then if something happens in the course of him doing certain work for the principal, then the principal will be held vicariously liable. You have studied agency law in commercial law, so again, here the issue of vicarious liability will arise. Okay, now I will have finished the topic of torts in cyberspace in this context. All right, and therefore I will stop here. And for your information, you will have the test on, I will give you the test on Thursday, but I will do the lecture. However, I will give you all a take-home test on Thursday, and then you can actually pass up the test on Friday. All right. So I'll give you a day to actually do your test. Okay. All right. I will give you more information in the WhatsApp. Right. All of you stay safe. Thank you.